Why did Scarlett Johansson file a lawsuit against Disney? Hello, this is Reinhard von Hennigs. And this big lawsuit between big actors or actresses against big companies are always the ones who make it on the top line of the newspapers. And now the question is, why? Or the question is, did she file this with the intent to win? Most cases like that, high-profile cases, end up in arbitration. Most cases like that are contractually agreed upon to go to arbitration. Meaning, if you file a lawsuit, the case will likely get kicked out very soon out of the court and pushed into arbitration. Why? Because at the time you signed the contract, you agreed for arbitration. Why is arbitration not that cool in this matter? It brings the matter behind closed doors. The court is public. Everybody can listen. The media can listen. So therefore, to go court versus arbitration is a cry out for media. But why does Scarlett Johansson want media? It all boils down to Black Widow, the movie which was launched and at the same time not as contractually agreed upon in 1,500 movie theaters nationwide, but also for download on Disney+. And that's where the crux of the matter is. Scarlett Johansson believes the more people have a chance to stream it, the less people go to the movie theaters, and she had an extra payday if the movie scores well and makes money in the movies. So therefore, she has a vital interest in that. The problem is the contract does not call for an exclusive movie period, and therefore the case may be weak. Is it weak enough for a dismissal? Maybe. Is it dangerous enough for getting it settled? Also maybe. At the end, most parties will watch this lawsuit with high interest, maybe as high interest as the movie Black Widow itself, and look into what does it mean if contractual agreements are broken. The contract calls for arbitration, but only between the company and the actress. Here, the actress filed not against the company, but against an affiliate company and called it now in tortious interference with business relation. All interesting arguments, all interesting legal court cases will bring up, but at the end, it boils down to if you are in a contractual drafting agreement and you sign for an arbitration clause, you should mean it. Otherwise, you should not sign for an arbitration clause.